Well,
I've seen too many people die from 22 revolvers
yep.
to say that there is a sufficiently delineated danger scale. You will not get me to go on record with the danger scale.
We are the Armed Attorneys. Today we're talking about a brand new case that has landed that relates to the legality of machine guns. Now, this is, I will say, one of the most promising developments we've seen in quite a while. Now, there's a little bit to it. Does it apply to everybody? What's the scope of this? And how did the court kind of reach this decision? We're going to be covering all that. But before we begin, show your support for the Second Amendment by hitting that like button.
And no sponsor today, but we actually just wanted to take a minute and encourage you to go check out our friend Braden Langley at Langley Outdoors. His channel is really awesome. He does a great Pro 2A breakdown of current events. He also wades a lot more into politics than we do here, so I think it's a fantastic compliment to this channel if you like what we do. Plus, we just know him personally to be about the nicest human being on the entire planet.
Yeah.
So go check him out. He's awesome. His content is awesome. We want to show some Braden support right now. So, all right, let's get started.
All right, so the case we're talking about is the United States of America versus Justin Bryce Brown. This is case number 323 CR 123 CWRASH. Now, this is in the United States District Court for the Southern District of Mississippi, and this had to do with a motion to dismiss on a machine gun charge.
Yeah, so this is, most of the time when we're talking about cases with you guys, most of the time, it's like a big splashy constitutional challenge to some law where basically there's a bunch of pro-gun groups and they gather some individual plaintiffs and they say, let's go take on the government. But this is actually a criminal case, which in the days before Bruin used to be how we got a lot of our Second Amendment knowledge. So, criminal case, guy actually charged with being in possession of a machine gun without having his government papers. So, what happened?
Well, so we have this, and there's two kind of ways we approach these types of cases. We have what are called as-applied challenges and facial challenges. Now, as-applied challenges are, hey, me as an individual, what does this law mean to me? A facial challenge is saying, under any circumstance under which you apply this law, it's not going to be constitutional. And in this case, we have just a facial challenge. So this doesn't apply to everybody, but I'm very hopeful, and we'll talk about that in just a moment. So this is just applying to Mr. Brown. But ultimately what he's arguing is, hey, guess what? In light of New York State Rifle and Pistol Association v. Bruin, there is no historical precedent for this machine gun ban, for lack of a better word, that went on the books in the 80s. We're looking at historical analogs, looking at kind of standards the courts are giving us with dangerous and unusual. We'll talk about that in a little bit. But ultimately, hey, guess what? He wasn't out harassing people or threatening people. And the court even points this out and says, hey, you know what? If you had somebody who bought a machine gun, kept it locked in their house in a safe for 20 years, they would still be in violation of this law. And I think that's where they kind of start the discussion of maybe this doesn't make sense.
Right. This is which we talk about all the time here, our auto sear you're wearing around like a necklace. That is currently, still, even after this case right now, currently a violation of federal law. You will get popped with a felony for having the sear around your neck like a necklace. So that's crazy. Equally crazy is you've just got something in your home. Why is it hot? Why is anything in my own home the government's business?
Nada.
Why is it hot lava?
Shouldn't be.
It should not be. So this is great. And in fact, I think this district court is highly sympathetic to that argument. Even saying like, look, going back even to Heller, let's not even talk about Bruin. Let's go back further than Bruin. Aren't we protecting the rights of people just to have stuff in their own home? Isn't that what we're supposed to be doing here?
Yeah, and this was in part of the conclusion of the case, and I think the court did a fantastic job here saying, all right, let's all take a step back here and look at Heller, let's look at Bruin, and even Rahimi to an extent. Really, what are these cases about? Well, it's all about distrusting constitutional law.
I loved that. Distrust of the government.
It's all about distrust of the government. And so that's why I think the court does a good job, rightly, focusing on New York State Rifle and Pistol Association v. Bruin, saying, hey, we can't trust our own constitutional law and jurisprudence when it comes to regulating the Second Amendment. We have to look to history.
Right. My face cannot be expressive enough for that statement because he's absolutely right. If we could trust our own government, Heller and Bruin would never have happened. Now, luckily, our own government via the Supreme Court ended up doing the right thing on those cases, but this is the situation that we've been left with. So we've got to look to the history, and he really focuses in on this dangerous and unusual provision, as this is the government's main justification as to why you still get to restrict machine guns after a Bruin. And I think he does an interesting analysis. He gives a little more than I would give, because he does go through this analysis about, well, what is danger? I mean, arguably semi-automatics are more dangerous than revolvers. And then if you accept that premise, unquestionably, fully automatic weapons are more dangerous than semi-automatic weapons. I'm not sure I'm willing to go that far. Well, I've seen too many people die from 22 revolvers to say that there is a sufficiently delineated danger scale. You will not get me to go on record with the danger scale.
Well, but the court does a good job in saying it's not just dangerous in a vacuum, not just unusual in a vacuum, it's dangerous and unusual. So you have to have both of these things. And another principle and I think this is worth reminding our audience about, and I feel the frustration when we say, hey, look, we have this law saying we're going to judge Second Amendment infringements, and they're going to be presumptively unconstitutional under New York State Rifle and Pistol Association. Why aren't all these, or you look at Chevron, why aren't all these regulations just falling from the sky? Because they obviously violate our rights. And the court does a good job talking about, it's called the principle of party presentation. And if you want to look at this case, we'll have it linked in the description below. And it is probably the most concise version I've seen expressing this principle where, hey, guess what? We're not going to go searching outside of our case for facts. We're going to look at our facts just right here. And that's really what all these other courts are doing. It's implied, but I think this court does a good job saying, you know what? Some prosecutions, they're going to do a great job trying to dig up some history and some tradition. Some courts are going to do a bad job. We have to focus on what's in front of us. And I think that's just a good reminder for everybody else. But going back to this unusual, it's not unusual.
It's not unusual. I mean, he says, what, 750,000 rough estimate?
Those are rookie numbers. We got to get those numbers up.
I think those are rookie numbers. But he's like, look, man, that's not even unusual. I love that, because I do think that a different court could have come to the opposite conclusion. Could have pulled like, well, we think there are this many handguns in circulation. We think there are this many rifles in circulation. And so in comparison, look at that. And that's basically what the government was gunning at. That's what they were arguing for. And he just didn't buy it. But I mean, good for him. But I do think a less favorable court could have taken that same number and come up with the opposite answer.
Yeah, and so I guess it's left with, hey, what does unusual mean? It's not like we get an answer to that question, but it's kind of like
nukes.
Yeah, it's like you kind of know when you see it. I hate that standard, because then it's up to who's ever observing to determine what's unusual. So I don't know that this is a great standard that other courts can use as a jumping off point when, reaching their own conclusions. But I think, this isn't the first time we've seen an as-applied challenge to a machine gun ban struck down, but this is the first time where I see, hey, we have some logic consistency here that I think other courts are going to find this very persuasive.
I would hope so. I would say this is a very promising development. Do beware. We try really hard to give you, not that we're trying to be Debbie Downers on this channel, we try really hard to give you the correct information without like the fire and the splash and the like, this is a game changer, because that's just not how the law works. I mean, how many game changers do we get a year in law?
One every 10 years.
I was going to say, not even one a year, right? So, I mean, it's just, I wish we had more of it. I wish that was us. That's not our profession. So we are just cautiously optimistic and appreciate our little bricks coming down from the wall until something collapses. And eventually, something here will collapse. This is a great brick.
Yeah, and I think, all right, if there's not a game changer every single second, why do we do this? Well, entropy, everything is degrading slowly. That's just the way the laws of thermodynamics work. And if we're not constantly vigilant, pushing on these things, preserving these things, well, then our rights deteriorate. So I do think, in that sense, it is still extremely important we talk about this stuff, but you do have to take it with some of this stuff. I've seen some of these videos out here. You got to take them with a grain of salt.
Yes. And bear in mind, Richard was talking about party presentation earlier. I mean, when we look at these cases, we've got to see the right facts too. And this was the right facts, because not only did he just have this thing in his home untouched, but he had no felony convictions. He had no way for the government to assert that he was dangerous in any way. I mean, see Rahimi, right? Because
bad facts, bad law.
Bad facts, bad law. For all those Second Amendment lawyers we know out there who are like, we don't talk about Bruno. You know, you have a toddler. We don't talk about Rahimi.
Sure.
It's okay to say that we think Rahimi was wrongly decided. The Second Amendment world isn't going to end if we admit that, guys. Okay, I think Rahimi was wrongly decided. It was wrongly decided because of bad facts. So here, we've got good facts. And remember, that always makes a difference. And so when we watch these, when we watch the walls of Second Amendment restrictions crumble, we also have to wait for the cases that have the good facts.
Yeah, but if it was wrongly decided, that means it changed something.
It just drives me nuts.
Yeah,
anyway.
Well, it's getting cited all over the place as having done something to the law, as much as we want to put our heads in the sand.
I know, right?
So we got to pay attention to it. But we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. We also got some fun new mugs in the store down below. You got to check those out.
Yeah, cash only, no papers. Emily's favorite catchphrase. But please, as always, leave us a question and comment below. Until next time, we're the Armed Attorneys.